Would the escorts please come forward with their honored guests? To my left are the Supreme Court Justices present, Justice Brent Dixon, Justice Frank Sullivan, Justice Ted Bohm, Justice Robert Rucker. The Indiana Court of Appeals, Chief Judge James Kirsch. Judge Nancy Vadic. Judge Paul Mathias. Judge Michael Barnes, Judge Terry Crone, Judge Patrick Sullivan, Judge John Baker, Judge John Sharpnack, Judge Edward Najam, Judge Carr Darden, Judge Mark Bailey, Judge Melissa May, and Judge Margaret Robb. It's my honor to present you the Lieutenant Governor of the State of Indiana, Becky Skillman.
Thank you, Mr. Speaker. Pursuant to Section 3 of Article 7 of the Indiana Constitution, the Indiana General Assembly is convened for the purpose of hearing a message from the Chief Justice of the Supreme Court. Ladies and gentlemen of the House and Senate, distinguished guests, I have the high honor of introducing Chief Justice Randall T. Shepard.
Thank you all so very much. You know, as I've been privileged to give this report to you, over time I've usually spoken less about the Supreme Court or the Court of Appeals and Tax Court and focused instead on advances in Indiana's trial courts and in our city and town courts. This emphasis flows partly from the fact that the Constitution says I'm to give you a report on the condition of the courts, all of them, and partly because it designates my office as Chief Justice of Indiana, not as Chief Justice of the Supreme Court. But there's a more important reason why I focus so much time and energy on Indiana's trial courts. There were, last year, about 1.6 million lawsuits filed in Indiana. That's about 70,000 more than the year before. And more than 99% of them started and finished in front of a judge or jury in a trial court. Put another way, like justice in every other state, justice in Indiana is either delivered or not delivered in the 170 places where we hold courthouses and city halls and town halls. Nothing in state government, in fact, I suspect nothing in government, interacts with so many Hoosiers so often in any given year. We see perhaps 40% of the whole adult population through our doors in any given 12-month period. Now, there is, of course, a lot of talk about the litigiousness of modern American life, and Indiana, happily, is not as litigious as most places. But the fact of the local system of justice is not a new feature in America. You'll remember that a young Frenchman named Alexis de Tocqueville came through the new republic about 1830 and examined the progress of this new republic. Came down the Ohio River, as a matter of fact. Made a wrong turn at Louisville, should have gone north instead of south. But his journals, still read today, reflect that the widespread and local nature of the system of justice made a strong impression on him. Now, I was reminded of this recently as I worked my way through a pile of invoices for payments to local courts, places like Bluffton and East Chicago and Aurora and Evansville. You know that our most ambitious technology project is a statewide case management system for every single court. It is one to which we are completely committed, and one on which, at the moment, there's every reason to believe will turn out well. But these invoices reflected a different project, a genuine technology success achieved in 2006, and it had to do with automobiles. Automobiles and motorcycles and buses and trucks, they are everywhere. And the system of keeping track of and holding people accountable for traffic law violations finds its way into every metropolis and every hamlet. People who plead guilty or who are found guilty of either running a stop sign or speeding or drunk driving are sentenced in some way, anywhere from points on a license to time in the state prison. And the record of that goes to Indianapolis from time immemorial on paper, in the mail. Somebody in the courthouse types up the record of what happened, and then somebody in Indianapolis is paid to do the same thing again, type it up again. In recent years, actually key punch it into the state's computers on which law enforcement personnel rely thousands of times every day. Now, since the early 1990s, the Bureau of Motor Vehicles has been striving to arrange for this to be done electronically. And by the beginning of 2005, after 10 years or more of effort, of the 200 courts that hear traffic and infraction kinds of cases, just 33 had been enlisted to transmit electronically. Since the beginning of 2006, we have raised that number from 33 to 156, and the other 40 are right behind them. This progress has only been possible because of the work of the Judicial Technology and Automation Committee, we call it JTAC, chaired by Justice Sullivan, and by the work of the people who work for Lily Judson, our state court administrator, and Mary Depry, the JTAC director, and by the excellent cooperation that we've had from the Bureau. Now, why does that matter? It matters because under the paper system, it took an average of 7 weeks from the time a judge, let's say, suspended a driver's license until the information about that fact showed up in the officer's computer. And so it was possible, indeed it happened, that somebody would get arrested for drunk driving, appear in court, have his license suspended pending trial, and then go back out at the courthouse door into the parking lot, get in the same car, which he's not supposed to drive because the judge just suspended his license, head back in the direction of the same tavern where he got drunk 2 days before, and if stopped for some other reason, like running a stop sign, be turned loose, because the information available to the officer would tell the officer that this was a person whose driver's license was in good standing. Things like that shouldn't happen, and I'm here today to tell you those days will soon be gone. Thank you. And that brings me to something else we're doing in technology to help combat domestic violence. Just yesterday, we began the first operation of a new electronic registry for protective orders in 2 lead counties, Blackford and Tippecanoe. A major hole in the protective shield that protective orders represent has been the inability of officers to access protective orders when they're out in the field. And so if, for example, a battered ex-spouse sees her abuser out in the parking lot of the restaurant waiting for her and calls 911, the responding officers had no way to know whether the courts, let's say this happened in Blackford County to give the example, whether the courts where they live next door in Delaware County had issued a protective order or not. And if so, what the protective order required. Should I take this guy in for violating the order, or is there an order, or do I go on my way because the batterer hasn't done anything in my presence? Now, officers will be able to access protective orders electronically, statewide, and do a better job than ever before at protecting children and women, especially, who are the victims of domestic violence, and we have far too many of them. Last year in our state, those who faced real threats, 9,000 of them fled to shelters in our state as a place of safety. This, too, has only been possible, this change, because of the collaboration of court technology staff, local courts, prosecutors, JTAC, and, Governor, if I might say, the Criminal Justice Institute and the state police, who've been absolutely superb partners in this, giving us good cause to believe that 2007 will turn out even better on this and other fronts. All of us, in fact, can do a better job at protecting the victims of domestic violence, and we will. Now, our work in protecting children is undergone a dramatic change for a different reason. As we implement the decision you made in the last General Assembly to mandate that courts appoint an advocate for every child who comes to court because of abuse or neglect. That mandate was good policy, which is why it passed both houses unanimously. And we are implementing it in the most cost-effective way we can think of, recruiting and training volunteers who will act as watchdogs, as mentors, as advocates for abused and neglected children, and only for the child, one child at a time. This sort of advocacy for children and mentoring, like the increase in child protective caseworkers that you authorized in the last session, can really matter. It mattered in the case of a young girl named Kelly Russell. Kelly Russell came into the juvenile system at the age of 11. She and her two brothers lived in a house where she could literally sit and watch her mother inject cocaine, and in which her mother and father used the house as a place to manufacture meth. Her time in the juvenile system was only slightly easier. In the 7 years she spent under agency and court protection, Kelly stayed in 4 foster homes, 2 residential homes, 3 juvenile facilities, and the girls' school, 10 places in 7 years. And the only real stable figure in her life over that whole time was her court-appointed volunteer advocate, Gloria Parrish. Today, Kelly is a biology graduate of Purdue University. She's married, she lives in Lafayette, she volunteers her own time to train new child advocates, and she tells anybody who will listen that she wouldn't be where she is today if it wasn't for Gloria Parrish. And the two of them are here today, and I'd like you to meet them so we can say thank you for this incredible lesson of success. We have to do everything we can think of to replicate that story. The potential for stories like that is the reason you made the right decision in 2005, even though you knew at that moment it would cost some money to make good on it. Even when you rely on volunteers, it takes some money to recruit them and to train them and to place them and to support them as they represent children. And the fiscal note for that bill was $4.5 million. But in the end, there was no appropriation. Fortunately, the Department of Child Services was willing and able to commit $500,000 in federal funds as a start towards making this happen. And the news in 2007 is better than that. The Budget Committee has now recommended an appropriation that begins to approach that estimate, and there are people here in this hall who've made it a part of their public career to help with issues of child advocacy, people like Dennis Avery and Sheila Klinker. And it was, in fact, Governor Daniels on this front and others who asked you to make this change in Indiana law. And so I come today simply to say, in the words of a famous Brit, give us the tools and we will finish the job. I also want to report to you about work that trial courts are doing that make us smarter about crime. Trial court judges have devised new and inventive ways to separate out the worst offenders who need to occupy a jail cell at DOC, our most expensive single resource, from people who can be safely addressed, safely handled, safely supervised in local programs. And these local activities, these local initiatives spread across the state, partly because of the hard work of trial judges, partly because they are supported by our Indiana Judicial Center and State Court Administration, and you have confirmed from time to time the best of these. 10 years ago, you asked us to begin certifying local programs that deal, local court programs that deal with drug and alcohol offenders, and to train the personnel. Is the local court probation officer a person who's well enough trained and supported so he can make a respectable judgment, an assessment for the court about whether this is somebody who has to be sent off to DOC or somebody who can safely be treated locally. And 5 years ago, you asked us to do the same thing on drug courts, and last year you asked us to do the same thing with respect to reentry courts. These are the courts that focus on people who are coming back to the very communities where they committed their initial crimes after time at DOC, and what it is you can do to make sure they simply don't go back to the old neighborhood and reacquire the old ways. The judicial term for this sort of approach is what is called problem-solving courts. It reflects attention not just to whether the court conducts a hearing and imposes a sentence, but to whether the particular sentence imposed does the best possible job at the lowest possible cost of preventing the offender from reoffending. And some city and county governments and local social agencies, and in a few instances the Department of Correction, have been willing to put up money to help build on that sort of promising approach. And so now we have some 40 communities where these very intensive local efforts are underway. We've also been examining, trying to be hard-nosed about it, the relative success of that sort of approach. And we've been testing drug courts, examining drug courts with an outside consultant in 5 counties. We have results from 2. I'll tell you about those. In Vanderburgh County, people who go through the local drug court at a cost that is half what it costs to imprison equivalent offenders, people of equivalent track record and equivalent risk, reoffend 17% less often than the people who are sent to prison. Put another way, the results from St. Joseph County show that 85% of the offenders sent to prison are rearrested within 3 years, as compared to 54% for people who go through the St. Joseph County drug court arrangement. More of this progress can be made, and we thank you. We're grateful for the help that you do in making it happen. Now, I think the most dramatic thing that happened in our world last year was the sight of hundreds of court employees, court clerks, and judges trooping off to Spanish class so that they could communicate better with people who come into the court who don't speak much or no English. Think about the kinds of questions that get asked over and over and over again. Which court am I supposed to go to? When is my court date? Where is the clerk's office? And if the court staff can't communicate at that basic level, the very complicated nature of court proceedings gets tougher for everybody. To help overcome these barriers, the Supreme Court partnered with Ivy Tech Community College to develop a workplace Spanish training program for Indiana's courts, featuring 24 hours of classroom instruction and a textbook and a companion CD so people could relearn at home things they learned in class. They go to class at one of Ivy Tech's 17 regional campuses. And since we started that program last summer, almost 500 people from local courts and clerk's offices have enrolled in this course from 34 counties, including Perry and Posey and Pulaski and Scott and St. Joe and Stark and Tippecanoe and Tipton, just to give you the P's and the S's and the T's. And why does that matter? Well, Judge Robert McCallum from up at Wabash was interviewed by the Wabash Plain Dealer about this program, and he said, I had the experience in my courtroom, a young man who was here for part of a day reporting program. This is one of those problem-solving arrangements where you pull in the offender, make him come face-to-face with the court first every day and then every other day, and then, if things go well, once a week and so on. And he said, the thing I noticed was that this young man would periodically turn his back on the proceedings, on me and the prosecutor and whatever else was going on, and look out into the audience at his parents. And the judge said, my first reaction was that he was either being disrespectful or he wasn't paying any attention. And then I realized that the student, the late teenager, spoke enough English to participate in this court hearing, but his parents didn't have a clue. And what he was doing was turning around to explain what was happening in court, to translate, in effect, for his parents. Initiatives like this language program and the enthusiasm which local court personnel have greeted it reflect a strong determination to serve people of all backgrounds, whether they're litigants or witnesses or relatives or anybody else who comes into a courthouse hoping for justice. And the enthusiasm of local court personnel that's been reflected in this experience is exactly what we'd want to have happen in an Indiana courthouse. It's the kind of state that we ought to and are be. It ought to be an R. You're a generous crowd. Now, projects like that can, in theory, be launched in a single court or a single county, but it's not very easy. And in the example I just mentioned, Judge Barbara Bruneau of Terre Haute generated the idea for a language program, a committee that she chaired, and our Judicial Center put together a plan with Ivy Tech. They tested it in the courts of Vigo County. And then the Supreme Court rolled it out at state expense, an expense lower than it would have been because we only had to invent it once and because we were dealing in volume. And Mr. Speaker, I want to tell you that your associates at Ivy Tech were the best partners one could have hoped for. I don't know that we could have done this without the flexibility, the cooperation, the imagination of people at Ivy Tech. And so a good court system, like state government, has room for both local innovation and state participation. And I want to mention two other parts of the court activity, which I think could be improved through similar approaches: indigent criminal defense and probation and community corrections. In both of these, Indiana still operates a patchwork in which there are various hands on the lever, financed partly through local property tax and partly by fees and partly by the state general fund. And we would represent indigent defendants better on the one hand, and we would save money, frankly, at the Department of Correction on the other, if instead these elements of court-related work were budgeted by the state. I mention these today because of the upcoming discussion about property tax relief. Now, neither of these services represents a big enough item that they constitute property tax relief in and of themselves. But however that package might turn out, they would be respectable parts of a larger package, in part because the burden falls very equitably and evenly across all counties of the state. Well, yes, I speak today mostly about local courts, but all of this is not to say that we don't tend to our knitting on matters assigned to the appellate courts or to court offices here in Indianapolis. Even, you might be interested to know, international events affect the work of Indiana courts, as we, for example, periodically must work to replace judges or prosecutors called up for military duty overseas, as Judge Terry Snow was when he recently spent a tour of duty in Afghanistan, or as Judge Matt Hansen will be when he soon goes to Iraq to assist in prisoner evaluation. In another very different international vein, the need to construct brand new courts in the former republics of the Soviet Union has meant the new relationship between Indiana courts and the Ukraine, whose judges have been coming here on a regular basis to learn more about how to run a court system. And as for appellate litigation, I should mention that while the legislature has periodically added judges and magistrates to deal with growing caseloads in the trial courts, it has been 17 years since we added judges to the Indiana Court of Appeals, and in that time, as you can imagine, the caseload has grown enormously. The Commission on Courts, with Senator Bray in the chair and Representative Dvorak making the motion, has recommended adding 3 judges to the Court of Appeals. There are some barriers, as one can readily recognize, to that sort of proposal, including the natural reluctance some might feel about giving a governor from the other party new judicial appointments. Those are the words I spoke from this podium on January 17, 1990, when I last asked a Republican Senate and an equally divided House to create judgeships that would be filled by Evan Bayh. In the end, this has little to do with who controls which house or who holds the governor's office, and it is not about light work for appellate judges. My colleagues on the Indiana Court of Appeals are working at a record pace. I tell you, there are no early tea times in this crowd. Their record proves it. And we are now well above the number of appeals per judge or per panel that we were when I asked the General Assembly to create judges that would be appointed by Governor Bayh. And while I'm talking about the Court of Appeals, I want to make special mention of 2 of our friends from that court. I learned just recently, just within the last 10 days, that Judge Jim Kirsch, the Chief Judge, has decided not to seek a new term as Chief. And I want to say to him, on behalf of all of us, that people who watch closely, and indeed even the casual observer, would say that your work as leader of this court has been absolutely splendid. And we're glad you're staying on the court, but we congratulate you on the remarkable run you've had as the court's chief. Thank you for everything you've done. And the other person I wanted to mention, he's sitting so quietly I couldn't see where he was. Judge Pat Sullivan is reaching the age of mandatory retirement. Maybe I shouldn't have put it quite that way. He has been on this, yeah, right. He has been on the Indiana Court of Appeals since before there was a Court of Appeals. He became a member of the Appellate Court of Indiana on January the 1st, 1969, and it has been a remarkable run. We are a more just state because you have given your career to this cause, and we all thank you very much for what you have done. And while I'm talking about changes here in this building, I want to renew the offer I've made last year to help make the case to our fellow citizens when the General Assembly believes the moment is right to make that case, that better compensation arrangements that permit able people to serve or continue to serve in the General Assembly or in state executive branch offices is in the best interests of our state. Finally, my profession is one often characterized as a center of contention and arguments. We're partly guilty of that. But it's also a place where good people do many fine things, frequently for pay and frequently for free. Just 2 weeks ago, the Madison Courier reported a classic Indiana sort of event. We had an election contest, a judicial election contest in November in the Joint Circuit, which is down in Switzerland and Ohio counties, between a practicing lawyer, Switzerland and Jefferson. We have 3 circuits here and none of them gone up. Between a practicing lawyer, Steve Tesmer, and the incumbent judge, Ted Todd. It turned out to be a real horse race. 52-48 in the end, not recount territory, but a genuine contest. One of the things that affected the tone of that hard-fought election was that the 2 candidates had promised each other that whoever lost would show up to administer the oath of office to whoever won. And so it was on the 29th of December that quite a crowd gathered to watch as Steve Tesmer administered the oath of office to Ted Todd. I think most people, including our fellow citizens who watch us at some distance, would be surprised to know how often moments of that sort of respect, that sort of comradeship happen, not just in the legal community, but in politics, in government, in Indiana. And I tell you that we in the judicial branch will do everything we can to make sure that it will always be so. And that, ladies and gentlemen, is the state of your judiciary.
The Joint Convention is now adjourned.